Welcome and thank you for joining San Diego Real Estate Talk with Rosita. I'm Rosita Perez. I'm your host, realtor, and self-discovery coach. I get the privilege of helping people find their way home, whether home is a physical home or if home is discovering the core of who you are. Today, we're going to talk about your home and how it is part of the legacy you leave to your children. I'll unravel the importance and value of your home, not just as a property, but as an eternal gift, your legacy for generations to come. You know, as a San Diego realtor, I've witnessed the profound impact homes can have on families. So let's explore how we can transform your home into your legacy. The title for today is Crafting Your Everlasting Legacy, Trust versus TOD Deeds 101. I'm going to share a brief overview of living trusts, transfer on death deeds, as well as probate. So let's get started with probate. Probate is when a homeowner passes away without a living trust or a transfer on death deed. The official definition for probate is a legal procedure that takes place after someone passes away. It involves validating their will in court and overseeing the distribution of their assets to heirs or beneficiaries. The process typically incurs various costs, and they are costly. There's probate attorney fees, there's court fees, and possibly other legal expenses. It can also take several months to a couple of years to settle, depending on the estate and the complexity of it all and any potential disputes. Essentially, probate is an official way to wrap up a person's financial affairs, but it does come with expenses and time consideration. Let me share with you the overview of probate fee structure in California. These are how probate fees are calculated. Now, our state uses a structure for probate cases ordered under Probate Code 10810. This is where the executor and the attorney handling the estate are entitled to charge a reasonable amount based on the value of assets. And it's according to this schedule. 4% on the first 100,000. 3% on the next 100,000, and then 2% on the next 800,000, 1% on the next 9 million. That would be nice if we had that. And 5% on the next 15 million. Now, for estates exceeding 25 million, court approval is required for this fee. Let me give you an example, because those are just all numbers coming at you. So let me give you a specific example. We are going to work with a home, an estate that is valued at $500,000. Here's the fees that could incur around that with the probate attorney fees. It's a total of $21,000. So it's $4,000 on the first 100,000. $3,000 on the second 100,000, and then $14,000 on the remaining 300,000. Some additional fees could be extraordinary services above their normal duties that attorneys and executors can charge. In addition to that, you have creditor debts that need to be paid off, possibly a mortgage loan payoff. If there are any liens, you have to pay that off. And if you have to sell the property, there are realtor fees, plus closing costs, which are estimated at 1.5%. Just for the attorney and realtor fees, it's going to be approximately $58,000 taken off the bottom line of your net proceeds. Remember, the other fees, the mortgage, the creditors, the liens, those also have to be added to the $58K and will require court approval. Whatever's remaining gets distributed to the heirs or the beneficiaries. Let me share with you, I had a client who had to sell his home in a probate situation. He had to get an attorney, which was pretty costly, a probate attorney. There were certain hoops that he had to jump through in order for the court to approve the offer that he received. It took a longer period of time to sell than it would a regular transaction. I watched this poor guy who had lost his wife suddenly. They did not have a living trust or a transfer on death deed. More importantly, it is pretty grueling to have to process the death of a loved one, as well as selling your property in probate. So let me move into living trusts. Now, the definition of living trust in the simplest terms is a living trust is like a special box where you put your important things and you decide who gets what item when you're not around anymore. It's a way for making sure that your stuff is protected and goes to the right people without any problems. It's very clear and there's no miscommunication. A living trust is a legal arrangement and a living document. You can make changes during your lifetime and maintain control of your assets. The most important thing is that the living trust avoids your assets going into probate, and it ensures your wishes are carried out smoothly. So let me share with you 7 benefits for California residents who are considering living trusts. Number 1, there's a forward plan. A living trust is a positive plan to protect your assets and maintain management during your lifetime. You can make changes, you can add or remove assets, ensuring that your trust aligns with your evolving financial situation and goals. Number 2, flexibility in estate planning. Living trusts offer flexibility where you are in control and you can make changes anytime during your lifetime. This flexibility is key in California's ever-changing real estate property values, and if there's some family dynamics that change over time. Number 3, it's a smoother process. Living trusts can provide an effective way to transfer assets to beneficiary. It absolutely avoids the probate process, saving money and time, which means a quicker distribution of assets. Number 4, it maintains privacy. Living trusts have a higher level of privacy versus probate in California. It keeps your financial information private versus being available for public search. Number 5, tax efficiency. Living trusts contribute to tax efficiency, maximizing benefits for heirs while minimizing tax implications in accordance with California's specific tax landscape. Now, taxes are not my area of expertise, and it is important to have the most up-to-date information on taxes, so please contact your CPA. Number 6, the cost and time savings by having a living trust. Again, the most important benefit is to avoid probate. Creating a living trust will save you a sizable amount of money, as we talked about earlier, as well as a great deal of time for your beneficiaries. It spells out everything, what they want done, who they want it to go to. All of that is spelled out in your living trust, and it comes with your will as well. Number 7, a living trust provides legacy benefits for future generations. It protects your assets and benefits for future generations. A living trust helps you provide financial security for your loved ones. This way, your legacy will live on. To sum it up, folks in California thinking about living trusts will benefit by the flexibility, the asset protection, information is kept private, the tax efficiency, you can stay on top of your assets, and you can cut costs and save time. The biggest thing is you can build a legacy with lasting perks for generations ahead. Now, let me share with you my personal experience with the living trust. My father had passed away and he had a living trust. I was his executor. We went over the living trust in depth, and I knew exactly what he wanted done. I knew what items were going to whom, and the biggest asset that he had was his house. And it was super important to him that he had something to pass on to his children, a legacy. The biggest challenge I had in the living trust is that I have a huge family. So I have 13 brothers and sisters, and I'm on the tail end. So I had to maneuver how to manage all of his wishes, handle the funeral arrangements with the group of us, and trying to come together as a family to decide how to divide between 13, 14 people, how to divide this asset of house. We talked about keeping the house and whoever wanted to pitch in to maintain the home. And then the other option was to sell the house and split the proceeds. Or if someone, one of my siblings, wanted to buy the house, they would get a loan, pay us off, each of us off, and purchase the home for themselves. It was a tough process, mainly because I have a lot of siblings. However, everything was spelled out, everything was taken care of, and we just had to deal with the sending off of my dad, his funeral, and then splitting the assets. Okay, so the last option is transfer on death deeds. Assembly Bill 139, better known as AB 139, is the law that became effective January 1, 2016, creating a revocable transfer on death deed. We call it TODD. This particular bill expires in year 2032. It's a way for California residents to transfer residential property to named beneficiaries effective upon their death. Now, on a transfer on death deed, it is just specifically for your home, no other assets. The transfer on death deed is like a regular deed you might use to transfer your California real estate, but with a crucial difference. It does not take effect until your death. A TODD is intended to be an inexpensive way to plan who inherits your home after you die. It can only be used to transfer property. So this is important to note. A TODD can only be used to transfer property with 1 to 4 residential dwelling or condos or single-family residence with less than 40 acres of agricultural land. Here are some of the challenges. Limited flexibility. There's no ability for specifics. It's only for your home, no other assets. There could be potential disputes among beneficiaries. And a beneficiary must be 18 years old to manage or transfer the property into their name. Lastly, if the named beneficiary dies before the property owner dies, the deed becomes invalid, and the property could then fall into probate upon the owner's death. Is a TODD better than a living trust? Both protect assets from going through probate upon the creator's death. The living trust has more flexibility than the TODD. The major benefit of a TODD is that it can bypass probate. That was a quick overview of probate, living trust, and transfer on death deed, better known as TODD. I hope this information is valuable and, more importantly, motivates you to protect your assets with either a living trust or a transfer on death deed. I encourage you to gather your asset information and determine what your needs are, what your goals are. Who do you want the property to go to? Which device are you going to use, the living trust or the transfer on death deed? Then schedule your appointments with an estate planning attorney and a tax attorney to get personalized details on your situation. Now, if you plan to do a transfer on death deed, I can provide you the forms as well as the information you'll need to file the form, because it needs to be filed with the county recorders. All righty. Thank you so much for listening. That's it for me today. I hope this information was valuable. I'll add the link so you can subscribe and listen to my past videos or get on the list to listen to my upcoming videos. When you have questions regarding real estate, please reach out. My number is 619-665-9086. If you'd like to search for properties, my website is rositasellshomestoday.com. Thank you for listening to San Diego Real Estate Talk with Rosita. When you need help finding your way home, whether home is a physical home or if home is discovering the core of who you are, I am here to help. Until next time, thank you so much. Hope to see you soon. Bye.